I'm Kate Unger Davis, and I graduated from Penn Law in 2011. My appellate court clerkship, I do 4 primary tasks as a circuit court clerk. The first is that I evaluate the appeals that come in to decide whether they should be argued or submitted. So I will read all the briefs, read the entire appendix, do my own independent research, looking to see what the district court did, if they got to the right conclusion, if they used the right analysis, and deciding whether or not it would be helpful to hear from the parties, or if the case can be decided really on the basis of the briefs alone. The second thing is that when a case is argued, I will draft bench memoranda, and bench memoranda are very detailed. There's usually a summary of the case, of what happened below, of all of the facts, of the arguments the parties are making, and then the sort of legal landscape, what the law is, and an analysis of what I think of the issues. And then once it's been argued, or if it's been submitted, I will either work on a precedential opinion or a non-precedential opinion. So non-precedential opinions, at least in the Third Circuit, tend to be short. They tend to not have too much new law, and they're not authoritative other than that they're binding on the parties. Precedential opinions, on the other hand, require a great deal of thought, a great deal of care in crafting them, because they usually are setting out new points of law that are binding on the Third Circuit, obviously, and the district courts. And it's an interesting process because not only are you then writing for the judge you work for and you have a relationship with and you have a good feel for how they think and where they'd like to go, but you're also then drafting and working to write an opinion that hopefully 2 other judges will sign on to. So that's been very interesting. Circuit court clerkship is a little bit different in terms of the tone you can take and what you're looking at and considering. Oftentimes in crafting a precedential opinion, you're not only looking at the case in front of you, but what possible ramifications this is going to have in the future. And that's a bit of a different style of thinking than I think the district court is usually accustomed to. At the district court level, you're usually looking for what the law is and how do I apply it here. You're not necessarily concerned about what iterations are going to come out in the future.